and welcome to this week's first edition of the Watchdog. And on the show tonight, the South African justice system is sharpening its teeth in the fight against gender-based violence. To explain to us how exactly, Deputy Minister of Justice and Constitutional Development, John Jeffrey, is my first guest. In a bid to overturn the High Court judgment declaring the release of former President Jacob Zuma on parole unlawful, the Department of Correctional Services and former Zuma's legal teams presented their arguments in the Supreme Court of Appeal sitting in Bloemfontein today. Legal experts Dr. Mkhuseli Vimba and Mpumelelo Zikalala are going to weigh in. We also get an update from the Department of Health regarding the latest case of monkeypox in the country. The Watchdog starts now. President Cyril Ramaphosa has signed into law 3 pieces of legislation aimed at strengthening efforts to end gender-based violence. To unpack the 3 laws directed at combating the scourge, we're joined on the line by Deputy Minister of Justice and Constitutional Development, John Jeffrey. Good evening, Deputy Minister. Thanks very much for your time. Well, quite a number of provisions that we're going to get into the details of just overall what the thinking was behind all these 3 pieces of legislation put together. Overall, what is it that you want to achieve?
What we want to achieve is to sharpen, tighten, as you've said, existing bills or acts rather. So in particular, the Sexual Offences Act, Criminal Law Sexual Offences Act, and the Domestic Violence Act. And then the third act that has come into effect is a more general one, amending a number of provisions. I can give you a brief summary of the main points for each act, if you like, or whether you want to ask me on that.
Let's start perhaps with the courts. I mean, virtual courts are going to be a particular feature. Why is that so important?
Well, there has been provision in the Criminal Procedure Act for people to be able to give evidence virtually. That's been in our law. During the time of COVID, when people couldn't travel that much or gather, use was made of the COVID regulations to allow evidence to be led in civil matters as well, virtually, and for virtual proceedings. So one of the acts, that's the Criminal and Related Matters Act, does now provide for virtual evidence and virtual proceedings in not just criminal cases, which was the case before, but also when it comes to, well, it's just obviously easier for some people to be able to testify virtually, particularly if they're experts. Yeah.
Witness fees. Let's talk about that.
Yeah, well, if you're a witness, you're entitled to witness fees. Those provisions basically remain. Obviously, the amount that witnesses are paid gets increased in line with inflation.
But then, does that not mean, what's the benefit to the taxpayer? Because, I mean, if these costs are going to be lowered, what's the benefit of that? What does it mean at a very real and practical level?
No, the cost would increase with the inflation rate, but the whole issue of witness fees is if the witness is not able to get to court, hasn't got food while they're waiting in court, they would get paid witness fees, which will pay for their cost of travel, probably pay for food as well. So it's a general point. I mean, not specific to gender-based violence and sexual offences, but that witnesses that are needed in cases can qualify for witness fees. That's an old provision as well.
Okay, I think really new. Let's talk then about the role of intermediaries who obviously, give support to people who come before the courts. What have you tried to, or how have you tried to strengthen that?
All right. Well, the intermediary system before the Act came into effect basically was that if the witness in a criminal matter was a child or a person with a mental disability, they could testify through an intermediary. Mm-hmm. And that would be a person who would sit with the witness, the child, listen to the question being asked by the prosecutor, the defense lawyer, the presiding officer, the judge or magistrate, and then phrase it in such a way that it is easier for the witness to understand, and then relay it back to the court. Mm-hmm. This generally takes place in a separate room, and they're able to be seen by everyone in the court, but they can't see what's going on in the court, so the child witness doesn't have to get scared by the accused. So that was the situation before. What these bills now do, or what the acts now do, is to extend the people who can apply to have intermediaries. So if somebody is suffering from a mental condition, they can use that as a basis for saying that they should get an intermediary. So it's not just children and people with mental disabilities. The use of intermediaries has also been extended beyond criminal matters, because they're mainly used, or they're particularly used in rape cases. It's been extended beyond criminal matters to civil matters and other forms of proceedings. So if in an application for a protection order, which is effectively a civil matter, evidence needs to be given by the complainant through an intermediary, that can now happen.
Hmm. And one of the criticisms, of course, has been just how easy it is for perpetrators to get bail. Have you addressed that particular, or these bills addressing that particular problem of the justice system?
Yes, the Criminal and Related Matters Amendment Act addresses that. There's a number of provisions to tighten up on people getting bail in domestic violence cases, in particular, and gender-based violence cases. So some of the provisions are basically before you can currently get police bail if the case is minor. You can get prosecutorial bail if the case is not so minor but not so serious, and then all other cases have to go to court. With these cases, the gender-based violence cases, you can no longer get prosecutorial bail, where there's an agreement between your representative and the prosecutor to get you out on bail. You've got to go to court. When it comes to applying for bail, or before that, if the prosecutor doesn't oppose the accused getting bail, they now have to give reasons why they are not opposing. And when it comes to the bail application, the court is directed to hear, in particular, there's a number of provisions, but I think one of the main ones is the court is directed to hear from the complainant as to whether they feel safe if the person gets bail. Their views have to be taken into account. There's also a requirement that if you have a protection order against you relating to the matter or to the complainant, you've got to disclose that. And then the provisions for bail being revoked have also been tightened. If you haven't disclosed that you've got a protection order against you, that can cause you to forfeit your bail. So there's been an effort to tighten up the bail laws. Let me just say that I think many members of the public would probably like us to have a law saying no bail, but I think constitutionally that's not possible. And you can have a situation where somebody is accused who is innocent. Well, everybody is innocent until proven guilty. The court has to have the power to determine whether bail should be granted or not. And bail is about whether the witness or the accused rather, will stand trial or abscond, or not abscond, or whether they will interfere with witnesses. And in the gender-based violence matters, it's particularly the interfering with the complainant that one is worried about.
Well, of course, the other part of the problem has been the fact that perpetrators get away light sentencing. Have you tightened there as well?
Yes, that's also been tightened. A number of crimes have been added to the list of minimum sentences. And in sentencing an accused or a person who's been found guilty, the court also has to look at the impact of the crime on the complainant, on the victim.
And then people who work with vulnerable people, you're introducing a vetting of persons. Why is that one particularly important? Or why was there?
All right, that was there before for specific categories. So it basically was before, if you had committed a sexual offence against a child or a person with a mental disability, your name went on to the National Register of Sex Offenders. And if you were looking for a job with children or people with mental disabilities, like, for example, a teacher, your name would have to be, you'd have to get a certificate that your name was not on the National Register of Sex Offenders. What we've changed then with the Sexual Offences Amendment Act is that now it's not just sexual offences against children and people with mental disabilities, it's any sexual offence. You commit a sexual offence against anyone, an adult, it doesn't matter, your name will go onto the National Register of Sex Offenders. And we've also expanded the categories of people that are being worked with to include, we've got a group called, I think it's vulnerable persons, and they would include young women under the age of 25. The intention there was to ensure that if you had a young woman staying in university or tertiary residences, that they really have a right to know that none of the people working there, looking after them, have committed sexual offences. So that's where we've expanded the whole issue of the Sex Offenders Register.
But how is the register itself sort of being managed? How easy is it for people to sort of have access to that information?
Look, that was a contentious issue, particularly when this act or bill was being debated in Parliament. Some members of the public wanting access to that register. The registrar, the person who controls the register, is with the Department of Justice. There can be applications to them, but generally one needs to be very careful about the public having general access to the register. You can have a situation where in an urban area, residential area, or a block of flats or whatever, a child goes missing. People then discover that a resident is on the National Register of Sex Offenders, and they can get angry and take the law into their own hands, whereas in fact there's no evidence linking that person, and in fact that person has had nothing to do with the missing child. So that's where one's got to be careful of vigilantism.
But then you've also introduced the obligation to report from people who may have knowledge or may know that someone is, committed an offence that perhaps they were not jailed for. Talk to us about the introduction of that particular aspect.
Yeah, well, that's particularly with regard to domestic violence, or any form of violence, really. The provisions are that the particular functionaries, social workers, etc., and I think broader members of the public must report if they suspect, must report to a social worker or to the police if they suspect that a child or a disabled person, vulnerable person, has been subject to domestic abuse. There were debates in Parliament as to whether that should be extended, and it's a crime, sorry, if they don't. There were debates in Parliament as to whether that should be extended to anyone, because there is a problem in many families where the son is abusing his wife. Everybody in his family knows that, but they just look the other way and hope it will stop. And in the end, it doesn't. He kills her. But the view, particularly when it was in Parliament, was that that would be taking away the victim's agency. They may, for whatever reason, not want to disclose it, may want to hope that the situation will get better. So those are the provisions relating to the duty to report.
In other words, you can't say it's none of my business or look the other way.
Yeah.
Then again, Deputy Ministers, people would say, I mean, it's good to have these great laws. And people would say, I mean, often say we are good at putting documents and policies in place, but the implementation is always the problem.
Indeed. The laws are implemented by people. And obviously a lot of training is being done for court staff, for police, for magistrates on these amendments. But people unfortunately still get it wrong, and that is a problem. Whenever somebody has done something wrong, that should be reported to the relevant officials, court manager, or taken up so that that person there can be an investigation into that person's conduct and corrective action can be taken. But yes, it is a problem. We do have good laws, but often the problem is with the implementation. Let me also just say that gender-based violence, or particularly domestic violence, sexual offences are particularly difficult, or particularly domestic violence, where this is conflict that's taking place very more often than not in somebody's home, between a person and their family member or their partner or ex-partner, and it's very difficult to police that. You can't put a police person in every bedroom of a person the bedroom of every person who's complaining about domestic abuse. So it does make it more difficult. Also, even with rapes, I think the chances are, I think more people are raped by somebody they know than by a stranger. So it's the criminals are not aliens from another planet or some other group of people. They're people we know, usually men, somebody's father, somebody's son, somebody's brother, somebody's husband, etc.
Just from conversations, Deputy Minister, I mean, when you look at the justice system in its entirety, where do you think there are particular weaknesses, or the system is most vulnerable?
I presume you mean with regard to the gender-based violence cases?
Yes,
yeah. Look, particularly with sexual offences cases, the cases take too long to go to trial, and that's something we've really got to work a lot harder on improving. Obviously, all the evidence has to be ready before the matter can go to trial, but it's not right that people have to wait for years to have their case heard, and they have to relive the trauma of what they went through. We are trying to reduce secondary victimization with the sexual offences courts, with the services offered there. But obviously, it's a very difficult situation for the victim or the survivor of the rape. The domestic violence matters, obviously the issue there is to be able to get an interim order from the court as speedily as possible and getting it served on the perpetrator or the alleged perpetrator, and then also to ensure that if the perpetrator breaks that order, that he is then arrested.
Just with regard to the courts, though, where lies the problem? Is it a resource issue, or is it a time or case management issue? I mean, I remember the Chief Justice when he was giving, his report some months ago. These questions were also asked. But as policymakers, from where you sit, is it a resource issue? Is it the way cases are managed? Where lies the problem exactly?
I think a lot of the delays are with the investigation. We had a problem not so long ago with DNA results, which were particularly needed in sexual offences where the accused did not admit to having sexual intercourse with the complainant, with the victim. So that causes delays. Obviously, then there's the issue of the accused have their rights. People often ask, but why do you give a criminal rights? But they're not criminals yet. A person has the right to be presumed innocent until they're proven guilty. But sometimes accused persons, people do abuse the system in terms of perpetually changing legal representatives and trying to delay the case. That's an issue that really, I think, requires the presiding officers to take a firmer line on it. But we do have to accept that an accused person has not been found guilty of being a criminal as yet. They may be innocent, and they have rights that also need to be respected. So, yes, I do think that case management often, well, there's a lot of improvements that can be made all over, but things would vary from place to place.
Okay. John Jeffrey, thank you very much for your time this evening.
Thanks for having me.
He is, of course, the Deputy Minister of Justice and Constitutional Development on the back of the President signing those 3 gender-based violence amendment acts. Up next, South Africa has recorded its 4th monkeypox case. The latest case is of a Western Cape man who had traveled to Spain. Sibongiseni Dlomo, the Deputy Minister of Health, is joining us on the line to give us an update on what the department has planned as the next step. Good evening, Deputy Minister. Thanks very much for your time.
Good evening, and good evening to your viewers at home and all over the country.
Yes. Talk to us about this latest case and whether, in fact, we should be worried.
You would recall that the 3rd case was on the 10th of July. I'm sure even all of us forgotten. The 3rd case was in July in Limpopo, of also a tourist from Limpopo. From Switzerland who visited Limpopo. The 2nd case was on the 20th of June in Western Cape. 1st case on the 22nd of June. Now, these cases are quite few and far between. Therefore, we are just raising it because we have actually made monkeypox a notifiable disease. But it is not really a burden as it is, you can tell, compared to what is happening in other countries and other continents. So we would wait for, Minister is going to give a detailed briefing on Friday as to what is our plan to deal with the monkeypox. Not because it is a concern, it's a big issue, but it's just that we need to actually work in tandem with the specialists, with the laboratories, both private and public, and be able to give a protocol of how to really go forward with this. But you probably recall, all the time we have talked about COVID-19, we said the legacy of COVID, among other things, will teach me and you just on the personal hygiene to say, if I were to be with you in that studio, but stay a bit far away from you without touching, have a handshake, even if I do have a monkeypox, I will still leave that studio without infecting you because it is spreading by contact, close contact to another person.
A person then may ask, Doc, what then is the point of making it notifiable if indeed there's nothing to worry about?
We don't know the future. It's a big issue in other countries. We are just lucky we don't have it in our country as yet. where we would not know whether we will hold on to the immunity for how long. But notifiable, it's just to make sure we don't make people to panic, and notifiable so that me and you, once we have it, you can actually be able to get the closer contacts checked again, examined, and also report if they're beginning to develop symptoms, so that we do not therefore find an infectious disease spreading in the community without anybody noticing it. And the time we wake up, we say there's 10,000 people in the country. So we notify, we make sure reporting so that we could keep track and trace where they are, who are they, and therefore see how they also begin to be quarantined, treated, and then we move on. So that's an essence of notifiable conditions. That's how we look at it.
But from what experts have been able to pick up over the last while, is monkeypox getting any different? In other words, are there things that they may perhaps be worried about, or new trends? Is there anything that experts are perhaps looking at that may well be interesting or different from what they have known all along?
Well, it depends which part of the world you are at. Our scientists, specialists in South Africa, would still have to worry much more about me and you. How are we vaccinated? Are we getting boosters against COVID-19? How far are we in getting a vaccine for TB and HIV, more than really worrying about this? But in other parts of the world, yes, it is becoming an issue for them to really prioritize and make sure that their research findings, their priorities are on monkeypox, because you are getting about 5,000, 1,000 in some other parts of in Europe per day. We're getting one monkeypox every 2 months. So we would not really find our scientists spending more time on that process than it would happen in other parts of the world.
Deputy Minister, let me thank you very much for your time.
Thank you very much for your listeners.
We'll see, of course, later in the week when the Minister holds that briefing, whether there is anything new on this front. That detailed briefing later on in the week, as the Deputy Minister has just said. Time to take a quick ad break. When we return, legal experts Dr. Mkhuseli Vimba and Mpumelelo Zikalala weigh in on today's proceedings at the Supreme Court of Appeal, where former President Jacob Zuma is trying to overturn a High Court decision declaring his parole unlawful. Welcome back. Former President Jacob Zuma and the Department of Correctional Services are gunning for the Supreme Court of Appeal in Bloemfontein to overturn the High Court judgment, which declared his release on medical parole unlawful. For a legal analysis in this matter, we're joined by legal analysts Dr. Mkhuseli Vimba and Mpumelelo Zikalala. Good evening to both of you, gentlemen. Thank you very much for your time. What is at stake here, Mpumelelo?
The first one is the credibility of Mr. Fraser and the decision that he took to release the former president on parole. Mm-hmm. And then secondly, for the former president, is the possibility of going back to jail to serve his term. So I think for him, he would say, I want to be out of jail. I don't want to go back to the Correctional Services Center. So hence, this is why I'm putting up this particular fight to make sure that I stay out of prison. Mm. And for Mr. Fraser to say, I was simply applying my prerogative as per the Correctional Services Act, and this is the decision in which I'm prepared to go and defend in court.
Mm-hmm. For you, Mkhuseli?
Yes, Vuyo, thank you. I think Mpumelelo has summed it up nicely. But I think what is also important is the issue of our jurisprudence, especially if the issue of double jeopardy is considered by the court, because there may be a possibility that the court will hear the arguments by the attorneys of Mr. Zuma to say that this person has been out then do we want him to go back to court? So that will be really enriching our jurisprudence, and that will also go further to his current cases that are in court, if that is considered, because the issue of age, the issue of whether there is double jeopardy, the issue of age, the issue of best interest of justice will be taken into consideration. Mm-hmm. And if the court takes that direction, then surely that will obviously, or it will affect the current cases that he's attending in courts.
Mm-hmm. I think for benefit of our viewers, I want to go back to reasons that the former Correctional Services Commissioner gave a while ago when I asked him about this. Just take a listen. Okay, we seem to be having problems playing that clip. I hope it'll be ready in a short while. But let me come back to you. I don't know if you listened to some of the arguments that were being made today, whether anything stood out for you.
It definitely was from the former president's submissions in terms of saying they were pinning the point of saying, let's look at what the Act says and let's look at the prerogative of the commissioner. In this case, two, I wouldn't say competing sections, but they directed the court to section 75 and also section 79. 75, which then spells it out clearly and says, in certain instances, the commissioner can ignore or choose to not go with recommendations that has been stated as to when a person should be granted parole and simply use his own discretion. However, if you look at 79 again, when it comes to medical parole, it then prescribed by using words such as must and shall, that the report from medical practitioners must be considered before you take the decision of whether a person should be released or not. So those two competing points in terms of these particular matters stood out, which at the end of the day may lead the court in terms of saying there may be a few amendments that may be proposed in terms of tying those two sections together or providing clarity as to under what circumstances is the commissioner supposed to disregard the recommendations which come from the parole board and simply choose his discretion. But however, falling back on the default position, whenever discretion is given to you in a position of power, we must always make sure that it is lawful, it is rational, and procedurally fair. And in this case, we may find a few loopholes with regards to rationality, where you have medical reports which are going to tell you that someone can be able to stay in prison or can be able to stay in a detention center, and then you go against that particular recommendation. The most important question would be, on what basis are you disregarding those medical experts and substituting it with your own?
Mm-hmm. In fact, I believe we have one of the clips ready, and then Kusele, I'll ask you to come on after this particular bite, where the former Correctional Services Commissioner told us where his reasons why he actually took this decision. Take a listen.
With regard to, let's take Jacob Zuma aside. With regard to any person that has to take parole, there's procedures, there's law.
So what process was followed this time around?
He was placed on medical parole. He came into our facility. We have a responsibility to provide security and care. And as in all instances, when we admit a person into our facility, we make sure that we do a full assessment, including a health assessment.
Okay, so who did the assessment?
Our medical staff, okay, and our administrative staff, yeah, in the center.
And who was part of the process that then, on the back of that assessment, took the decisions that eventually led to him being paroled?
No, maybe I must talk about the process. You see, when you do the assessments, you'll then know what type of care must be given. So when we deal with care, we deal with even your dietary requirements. So every offender that is incarcerated at this department will have to be able to give a history of themselves, both health and otherwise. And then we assess how do we categorize them and where we are able to place them. This was in the same process.
Mkhuseli, I know how to think that just a little bit we listened to there. He was confident that he did everything according to the law.
Yes, in terms of the parole procedure, because I don't think the issue of procedure is in question. The issue is whether did he have the right to overrule the parole board, and or did he have the right to make that discretion? So I think that's a bone of contention to say. Now the parole board has made a decision to say, though they voted, we should also highlight that they voted, and the majority of the parole board members voted for him to remain incarcerated. Then at the end of the day, he made that decision which overruled the parole board. So the question is, did he have such powers in terms of the act to overrule the parole board? If he had such such powers, did he utilize his powers rationally? So the issue of rationality then comes in. And at this point in time, there is nothing. In actual fact, it was clear in the court or in court today to say that the judges did not have sight to his condition, that is medical reasons or condition that led to his deteriorating condition for him to be released on bail. On those bases, it was really difficult, or it will be difficult to decide whether he acted rationally or not. The other important thing is that as much as if he acted rationally, that will be dependent on that is entirely dependent on the reasons that were put forward to him to say this person can be released on parole. But it is important to note that in terms of the Act says that the person must not be at his last stages of life for him to be released on bail. If a person cannot take care of himself, or the medical facility or the prisons or correctional service centers cannot accommodate that person, which is the case in terms of the report, then that person can be released on bail, on parole. So the issue here is whether there were valid reasons for his release or he acted rationally or not.
But one of his central arguments from that interview, the former Correctional Services Commissioner that is that his condition was known and it had been declared. And because Correctional Services can't offer him, the former president, the kind of medical assistance in that he would require, he felt he should then be released because Correctional Services can't offer the kind of care that he would need. Take a listen to the former commissioner saying that.
He declared his comorbidities. But additional to that, because he was still under the care of the South African Military Health Services, they had also provided us an assessment on his first day of admission. So that is when we realized that we've got a person in our custody who actually is frail. So I think that's maybe the first point. We had then received further reports, medical reports, that indicated that he requires specialized treatment. And it was only around the third report that we received where his his medical team, the medical team, in conjunction with our team, indicated that he can no longer be kept in our facility because the type of care, medical care required, we are not able to provide. And this assessment is made with every other offender.
Mpumelelo?
I think that this proves the point of the reliance with the importance of the medical report. Now, if you are going to concede to that, then you must also concede that whatever decision in which you then take must be fully backed up by this medical report that you are referring to. It may be that maybe in the answering of these particular court papers that didn't come through in terms of saying, let me give you a full tour of what exactly did I look at when I made this particular decision as the commissioner. Or maybe why didn't I go back to the medical parole board and say to them, have you really looked at these particular instances and other reports that are there? I didn't deny or maybe ignore your report on purpose or maybe for my own intention. It was purely based on factual reports that I have received from medical practitioners, of which, by the way, the Correctional Services Act is very clear because it says medical practitioners, not only those which are linked to the medical parole board, but simply just medical practitioners. So if you then come back and defend the decision that you have taken, then maybe it could have been easier for Mr. Fraser to defend his position. Moving back to one single point of rationality, yes, lawfully, I do have a Correctional Services Act that allows me to take this decision. Rationally, these are the things or the steps that I've taken. And procedurally, this is the type of interactions and the right to give another person an opportunity to respond that I've given to the former president so that they're able to make a case in terms of what is happening. Maybe if he had provided that type of evidence to the court, the court may have been convinced, or maybe the court is going to be convinced depending on the type or the manner in which they've drafted their papers.
Just looking at what both sides are put before the courts today, Khosile, what do you think their decision, or the decision ultimately, is going to rest on?
Thank you for your. I think the issue of whether Mr. Fraser had the authority or to make a discretion to overrule the parole board will be what the court will decide on. And one important thing, if the court upholds the decision of the High Court to say Mr. Fraser's decision was unlawful, then that would mean then that Mr. Zuma will have to go back to jail or to prison. But if the court considers what has been put forward by Mr. Zuma's attorneys in as far as double jeopardy is concerned, putting the interest of justice outstanding in everything that the court decides, then there can be a situation, or the court can decide to say, because this person is still under parole, meaning that he is still a prisoner until he finishes his sentence. He has served a certain part of his sentence. Therefore, considering his age, considering the fact that he is still ill, because that is not in contention, the issue is whether Mr. Fraser had the authority to grant him or to overrule the parole board or not. Then we may see Mr. Zuma getting mercy from the court to say this person is already has already served part of the sentence because he's still a prisoner, even if he's on parole. So the court decides in favor of him in as far as the issue of double jeopardy is concerned. So those are the two issues for me that I think the court will consider in deciding this matter. Because the other issue that was advanced by Mr. Zuma's attorneys, I don't think it will work. The issue of taking it back to the current commissioner. The current commissioner has already made his intentions known to say that he feels that the issue of granting the parole to Mr. Zuma was okay. So on the basis of that, he cannot make another decision which would be unlawful, because he would still be overruling the parole board that has made a decision in this case.
Mpumelelo, is the law very clear on process? In other words, what needs to happen, before whoever takes a final decision? Or is that what the court is also grappling with? In other words, did Arthur Fraser have the powers to do what he did?
It is not very, let's not it crystal clear. It may be clear because we've been able to refine it as we're moving along. However, there are a few loopholes here and there, especially with how the Correctional Services Act is written in the type of mandatory requirements that one would have to engage in. You sort of have to read into, or maybe interpret it in a manner of saying, let's look at the whole act in its unison, and then we can be able to come back to this particular decision of saying, is this part of a requirement when one is looking at the powers of the of the commissioner? Now, let's also take into account that some of these amendments would have been due to the challenges that have been there in the past. Well, one matter which comes to mind is that of Mr. Shabir Sheikh, of which there are certain some amendments that occurred after that particular matter has been assessed or maybe has gone to court, and then they would have said there are loopholes here and there, how can we be able to fix it? But in terms of the Act being very clear as to where the discretion lies, the Act is very clear. It says that the Commissioner has all the discretion in order to determine whether someone should be released on parole or not. The manner or the type of parole that a person can be able to get is also very prescriptive. What is not there is a mandatory requirement of saying that you need to apply your mind in all these factors, so that at the end of the day, when you make the particular decision, that particular decision must be lawful, must be rational and procedurally fair. Maybe that's type of the amendments in which the court may even recommend in terms of saying, Minister of Correctional Services, we can see that you are presiding over a piece of legislation which needs a few amendments here and there. Can you please look at it so that at the end of the day, we are able to cover all these instances of disagreements or confusion that may flow about due to two sections not speaking to one another?
For you, Mpumelelo, I'm sorry, Kuseli, is the law very, very clear?
I think there are a couple of things that need to be clarified, and as Mpumelelo has indicated, this will clarify, or the decision of the court needs to clarify the powers of the parole board vis-a-vis the powers of the commission. And if that happens, then it simply means that because the language, as Mpumelelo has said, the issue that was contested in court today was to say that if the advisory body recommends, that does not mean that that is the final decision that the parole board has taken. So at the end of the day, someone somewhere must take that decision to say, I accept your recommendation, I accept your advice. As we stand now in English, whether we go anywhere else, the issue of when you are recommending, no one is bound to take that recommendation. So you have to have someone who is the final arbiter when it comes to the parole board. As Mpumelelo has said, there is a lot that needs to be done in the legislation to clarify these issues. Hence, I said at the beginning that this has a potential of enriching our jurisprudence, not only in terms of the issue of whether he had the discretion or not. The Act is clear, but the issue that they are arguing in court is that if you recommend, a recommendation may be taken. If you advise, their advice may be taken. But somehow, someone must take that discretion.
Judgment has, of course, been reserved on this matter. We'll see how it pans out and what the court is going to decide. Special thanks to our panel, Dr. Mkuseli Vimba and Mpumelelo Zigalala. And that's our show for tonight. To join us again tomorrow evening, same time. Have a good night.